I think he's got you turned on, Sam.
Okay.
I don't see anyone online yet. Is that true? Terry. Oh, Terry is. Welcome, Terry. My name is John Voris. I am actually a retired trustee, and that's the group here at the church that sponsors this activity with Sam on trust, as well as how you want to manage your assets after you leave this world. So sometimes that's a pretty boring, pretty unexciting activity. I will tell you that I have had family members that didn't get that sort of preparation done, and those last few months are very painful because paperwork wasn't set up, power of attorneys for medical, financial, and not doing that paperwork early really stresses the heck out of the family that is there to support you. So, real important thing to do. I will also say that we have a member of our church that wrote a book. It's The Economics of God's Plan. It is a very interesting, very detailed book about how God really benefits, not only if you follow God's plan, that you'll also reap some benefits, not only for yourself, but for your family, and how you manage that, and how God grows those benefits within your life. And sometimes that's financial, sometimes it's family, sometimes it's I'm going to say your skills, all the gifts that God gives. So if you are interested in Bill McKee's book, I have a few copies, and we'll make that available to you. That includes anyone online as well that joins us. So just give me your name, and so I can either send it to you, or on the way out the door today, just let me know and I'll give one. Okay, Sam is going to talk about establishing an estate plan, and Sam has many years of experience. We'll just call it plus 40. Let's not going to get out there and count too detailed. But Sam's been doing this. He is an attorney. He is very skilled and has done many trust plans here at the church for members of the church. So, good person to talk to. Sam has also been a part of the leadership of the church, both as an elder and as a trustee, and has spent many, many years working and supporting the church. His wife also sings. If you come into the church, you will often see her here. She's a very strong member. So I just want you to be aware that Sam is a trustworthy and honest individual. So that being said, I'm going to ask Sam to come on up and give his presentation on trust.
Thanks, John.
Thank you, sir.
I hope I'm on. Can you hear me? Okay. That's the most important line in the whole thing. I'm here to talk to you about estate planning today, but it's something that we all need to do, no matter how young we are or how old we are. I've got a little story to tell about a lot of things This one had to do with estate planning. My dad lived to be 93. When he got to be 85, he called me. He lived in Houston, and he said, I'm not coming for Thanksgiving and Christmas like I used to because my friends are telling me I'm too old to drive that far. And I said, okay, Dad, I'll fly down and drive you out. I knew he wouldn't fly. The last time he flew was coming home from World War II, and he just wouldn't fly. So I went down and drove him out here, and he stayed from Thanksgiving through Christmas. And on the way back, I had a couple of clients, one in Elfrida and one in Lordsburg. Anybody know where those are? Elfrida's south of Wilcox, and Lordsburg's in New Mexico. Anyway, the gal in Elfrida was a farmer, and she was pretty old. And we went there, and we signed her will and her trust. And we left, and we went over to Lordsburg. And there was a young couple that was in business. And when we left there, my dad said, do they know that they're sick? And I said, no, at least they haven't told me about it. And he said, well, why would anybody do a will if they're not about to die? And that brought up the conversation. I knew my dad had a will and a trust. And I said, when we get to Houston, we need to go see your lawyer and get it up to date because my mom had been dead 12 years by that time, and I knew he hadn't done anything to bring it up to date. Anyway, we're doing the family estate planning seminar, and I'm supposed to turn the slides. There's a slide that tells you who I am and where I am. You've probably got an email from me that has the email address on it, so we'll let that go. We're going to start off with the really basic stuff. What is estate planning? And a lot of us have never thought about that in terms of what happens before you see a lawyer. So here's the setup. We spend our lifetime creating wealth, and then we spend a lot of our later years on preservation, and that's your investments. And then finally, you distribute it. That means you give it away. And that's where you say, you mean I worked all my life to give this stuff away? Well, you can't take it with you. I haven't tried this on David Joint, but a previous pastor, I said, we need to get U-Haul to cooperate with us when we talk about estate planning and put a ring of U-Haul trailers around, and the sermon would be, you can't take it with you. He didn't think that was a cool idea, but I still think it's a pretty good idea. And I can tell some other stories about that, but we'll skip those. But on my slide, I've got parents at the top, because generally it's parents, and they're preserving their estate for their children, and it should say, and their charities. And that's where the Boy Scouts and where Valley Presbyterian fits in, because if you don't put them in your will or your trust, they don't get anything. And I've talked to numerous clients that say, well, I'll let my kids decide that. Well, your kids are going to decide that they're a more charitable need than the institution. So if you've got a favorite charity or a favorite cause, Valley probably has a fund in that name, and the Boy Scouts definitely have funds that take care of scouting. But we're not here to sell you on charitable contributions. That is an important part of life. And my experience is people that are charitable minded in old age usually are a lot happier. And I think that's partly because you know what's going to happen and you're going to leave it to something you consider a good cause. So I'm not saying cut out your kids, but I'm saying there's room for your kids and their charities. Okay. Okay. So one of the things that guides us in doing estate planning is, what does it cost? Well, the lowest cost thing is to not do anything, but it doesn't get your objectives conquered usually. It certainly doesn't take care of your charities, and it might distribute your estate different than you want, because the state has written an estate plan for you which is called Title 14 of the Arizona Revised Statutes, which is a big blue book that covers every conceivable option except yours. That's the way it always works out. Whatever you want to do is not in the statute, so that's why you write a will or you write a trust. Now, the other two considerations in this are fees, which are primarily attorney's fees, but there's court costs involved, and there's taxes involved. Then it goes on to your children and your charities. Now, the taxes, we're not going to cover that today, except right now, real briefly. This year, if you've got more than $12.5 million, you'll be taxed at 40% of everything over $12.5 million. I don't expect that all of you have that, or even if any of you have $12.5 million. But that number's going to change in a couple of years to $6.5 million. And the way things are going, it might even go lower than that, in which case some of you are going to get into the $6.5 million range, and that's where it's important to get into some serious estate planning, because you can raise it from $6.5 million to $12.5 million tax-free. So you can save 40% of $6 million, which is a huge number, and pass it on to who you want to. In addition, by using charities, that money's non-taxable, so the part that's taxable you could give to charities. That's all we're going to cover on taxes, unless somebody wants to ask me about it. Okay. Probate is the main way that estates are transferred. That's a court process, and it's one of the three basic options. Intestate succession, I already sort of hinted that if you don't have a will, the state's written one for you, which is Title 14 of the code. If you do have a will, you're going to go to probate anyway, but you've made your wishes known, so the statute doesn't apply anymore. And then the third way is a revocable living trust, which is what most people are doing when they get to the point where they're going to have a probate estate. And I'll cover this right now. A probate estate means that you've got $70,000, $75,000 or more that's not jointly titled with somebody. So that will require a court proceeding and an okay by a judge. And 9 times out of 10, it requires a lawyer. We see a fair number of people that come in and say, I went online and I went to the self-help center, and here's the forms I got, will you fill them out? And that's not what the self-help center was made for. The procedure is difficult. It seems easy to those of us that do it regularly, but it's a complex procedure, and you've got time deadlines and other kinds of things you've got to do. But it does get your estate transferred. Okay. Whoops, I'm going the wrong way. So we got through the no will, and a trust. Now there's a couple of methods that people use they think are distribution plans, but they're not. And the reason they're not is they only work between 1 or 2 people. After those 2 people are gone, there is no way for the property to move without going to probate. But joint tenants with right of survivorship, if you're married, that's the form you're going to use. And that will pass your property to the survivor. But when the survivor dies, they can't do that with somebody that's not their spouse. One time I had an old guy say, well, that's real easy. Every time my wife dies, I just marry a younger one. And he said, anyhow, joint tenants with right of survivorship and community property with right of survivorship. I just misstated that joint tenancy. That can be with anybody. It doesn't have to be your spouse, but community property has to be with your spouse. Let's talk about community property a little bit right now. Community property is all the money that you earn while you're married. All the money that you earn while you're married. Anything received during a marriage by gift, descent, and distribution is separate property unless you convert it to community property. Most people have defeated their community property by using joint tenants with right of survivorship, or by using community property with right of survivorship, which doesn't defeat the community property, but it does end when one of you dies or both of you die. Which I didn't say when I started. If you want to ask me questions, it's okay. I won't get any more confused than I am. So we can go along with, if you've got a question, then somebody else here probably has the same question. Okay, what is probate? This is the definition of probate. The administration of your estate by a court, by the terms of your will, or by intestate succession. So when you go to probate, that means you got to give 4 months notice to creditors. The folks that I deal with come in and say, Mom died, she doesn't have any creditors, we don't have to do that. Well, you do have to do that. Otherwise, you can't cut off the creditors. That's part of what probate's all about. Probate is to collect your assets, pay your bills, cut off your creditors. So probate will cut them off after you give 4 months notice to creditors. So the usual statute of limitations run from 2 to 6 years. So you're shortening up the time that it takes for them to sue you. And sometimes the lawsuits can be pretty big, especially if there's big medical bills at the end. So that's something you want to get on top of. My experience in sending out more of these notices than you can imagine is most creditors don't send anything in. So the claims evaporate in 4 months. Okay, probate. How much will it cost and how long will it take? I put these on one chart. You can look up there and see. Oh, okay.
On that, what you just said about probate, you go there even if you don't owe any creditors?
Yes. You have to get this judge's stamp on your papers, and you have to give the 4 months notice to creditors. Now that's if you have a probate estate. If you have a trust, you don't have to do that stuff because a trust doesn't die. A trust stays alive as long as you leave it alive. You kill a trust by taking all the property out of it. Most of the trusts that we write say as soon as practical after the distribution of this property, close the estate. And that means then the trust dies. But trusts can be written so that they stay active for a long time. A lot of people want that, but most of the time you really don't want a trust to stay active unless you have generational wealth that you need to transfer on down. So we still got the probate costs, and you just go across on your line and see. And that doesn't allow for any inflation. I made that up a couple of years ago, and the amount of inflation has been outrageous since then. And attorneys aren't exempt from inflation. I mean, we have to pay more at the grocery store too, so that's the way it works. Then down here at the bottom, if your estate's under 600,000, it'll probably take a year to a year and a half. We try to get those estates done quicker than that. And if it's over 600,000, 1.5 to 3 years. And the reason for that is discord among the heirs. That's the most important thing you've got to do as a person writing a will is get your heirs all on the same page. And selling real estate. We've been in a hot real estate market for quite a while now, so that's not a problem. But it can cool off where property just won't sell. And 9 times out of 10, there's nobody in the family that wants the family home. The kids grew up there in Phoenix and they moved away and they've got a life someplace else. They want to get their share of the family home and let it go. So, any more questions? Okay. Intestate succession, that's a fancy word for no will. It's an estate plan by default because you defaulted to the state of Arizona scheme. It requires probate, and there's no guarantee that the right person's going to get your property. And what do I mean by that? The statute has complex provisions for second marriages in it, and generally the second spouse gets a big chunk of the estate. That may not be what was desired, and on the other hand, it probably should be in some cases. I did a prenuptial yesterday for a client. She's 65, her net worth is $6.5 million. He's 75, his net worth is $41 million. In that case, neither one of them is planning to take care of the other one. But many times we have estates on these second marriages that one or the other has no assets at all. They get married, they have a Social Security check, and they're counting on their spouse funding the rest of their life. And that can be done with a trust, but not very well with a will. So intestate succession doesn't avoid probate, and the guarantee is not there. It may wind up with your spouse's kids, and you really intended for after the spouse is gone to go to your kids. So what is a will? A will is a pretty simple document taken in its simplest form. Dear Judge, please distribute my estate to my spouse, my children, my charities, my friend, whoever you want to have something. That's really all it is. It has to be signed and dated. Our statutes are pretty simple on that. It doesn't have to have anything formal about it. However, it's better if it does. And when it's signed and dated with no witnesses, you've got a problem as to authenticity. I had one case one time, a long time ago, where a gal came in and her sister had died without a will. And the niece had sent her a three-cornered piece of paper that says, I give everything to the niece, signed Betty. And she said, and it was dated. She said, this is what they're going to assert is the will. And I said, well, did your sister write that? And she said, no. I said, how can we prove that? She said, I've got 50 years of Christmas cards that she wrote notes on and signed. And in addition, I've got 25 years of Christmas cards from my niece where she wrote them to me or to my sister, and that is her signature. And I said, well, that's not going to cut it. We got to have an expert on this. So we looked around and we found a question. The technical name for this is question document examiner. And we sent him the three-cornered piece of paper, and he sent us back a written report that said, not only is that not your sister's signature, the whole thing was written by your niece. I sent the letter to the niece, and she disappeared real fast. But you don't need to go through that kind of stuff if you've done a trust. Okay, the advantages of a will. It's cheap at the front end. When I first started practicing law, I worked for a small law firm, and they actually did wills for free most of the time, but if they charged, they were $35. There's nobody doing a $35 will anymore. Even the will kits that you hear about on the radio and the internet are more than $35. While we're at the will kits, that has the same drawback to it as trying to do your probate, and that is filling in the blanks is not as straightforward and easy as it looks. So you can wind up making a real mess out of your estate. But it is simple during your lifetime to have a will, use a kit or use a lawyer, and now the results are guaranteed. If you want your oldest son to have everything This is one I have great difficulty with foreign-born clients. They believe that the oldest son should inherit everything. And I argued with one the other day, and he said, well, my daughters have husbands. They can take care of them. Well, one of his daughters didn't have a husband. She'd been divorced, and she didn't get a very good settlement. So she's out in the cold, and the son gets $1 million. Not a real cool idea to keep harmony in your family. Okay. The disadvantage of the will. It requires probate. There's no way to avoid probate if you have a will and you have $75,000. If you got less than $75,000, then you can use an affidavit that says, I've got less than $75,000. It does not have to say all the bills are paid. It just says I've got less than $75,000 and I'm entitled to the money. And you take that to the bank or whoever has the money and they hand it to you. So you can't avoid probate on small estates. It's more expensive for the heirs. For starters, you're going to have to pay a filing fee at the court, which is going to be about $370. Then you're going to have to serve the people, and you're going to have court hearings. There's going to be substantial time delays. That's caused by the 4-month notice to creditors, which I told you how great that was a little while ago. But the other side of it is that you have to have the time delays to get the creditor notice out. And it's public. This is the one that, for even modest estate people, a public process is not something you want to happen, because here's what happens. There are people that I call vultures that read the obituaries every day, and they go to the courthouse and look up those people to see if they filed a probate, because the mere fact that you filed a probate means that you've got property of some sort. Then they start looking for your property, usually real estate, because that's easier to find than anything else. But there are online services that can get into your stock accounts too. But the process is public, and you're subject to vultures that'll be trying to take the property away from you. As a young lawyer, I was involved in several of those, and they're not pleasant. And they're not something you want to get involved in. And they usually take the money away from somebody that really needs it. So the general rule, if you have a will, or if you don't have a will, you will have a probate, then it's going to go to where you want it to go. Now, I've got 3.5 exceptions up there. Joint tenants with right of survivorship, that's sort of a half exception because it runs out after 2 lives usually. Small estates, which I just told you about, that are under $75,000. Revocable living trusts and living wills. Whoops, I said living will, I meant living trusts, and then beneficiary deeds. Beneficiary deeds for modest estates are a nice way to go. You can set up your estate to go to beneficiaries, your accounts, so bypass the will is what you do with a beneficiary deed. But the one place you run into a problem is with your house, because using joint tenancy is not a good idea. It puts somebody on the house that may have a judgment problem, but a beneficiary deed delays that until after you've died. And you can change a beneficiary deed at any time. So you've got 1 or 2 kids, you write a beneficiary deed, you sign it, you record it. As long as it's recorded before you die, then your house will go half to each one of your kids, and there won't be any probate, and your bank account will go to whoever you put on there as beneficiary. So that's a good way to handle a smaller estate. Now, the types of trust, we're going to get into more talk about trust. The usual trust people are talking about is a revocable living trust. The wills that we write have what are called testamentary trusts. The rest of the name of a will is last will and testament. So the testamentary trust is written in your will and does not become active until the end of probate. We see what the disadvantage is. You still have to have the probate. We used to write a fair number of those trusts for young couples on the hope and desire that their kids would grow up and their mom and dad would get wealthy enough to make a trust later on. But the testamentary trust is not a good idea, and then it has to be court supervised on top of all that. A living trust is a two-step process. The creation of the trust, and that's what you and the lawyer do together. You decide who's going to be the successor trustees, who's going to be the beneficiaries, and what the terms are going to be. And then the property transfers. Most lawyers in Phoenix will do the deed for you. That's part of the deal, that part of the property. But changing your bank accounts is something only you can do. Changing your investments is something only you can do. So that's what makes it a two-step process, and that's also where the thing fails. Because if you write a trust, the lawyer transfers the real estate. The trust is now good, and you've got to do the property transfers, and if you don't do them, then you're faced with a probate. The probate, the will that we use says give it all to my trust, so it winds up in the same place, but you threw a roadblock into your planning process. Okay, living trust, we're going to talk about a three-cornered hat. You're going to wear all three of them at the beginning. The trustor is the maker, the trustee is the manager, and the successor trustee is the manager after you die or become incompetent. The beneficiary is the trustor, the maker at the beginning, and then whoever they've named in the will, heirs, the charities, whatever. So that's how a trust is created. So you got a three-cornered hat. I ride a bicycle a bit. Sometimes I think I ought to wear a three-cornered hat because when you get to an intersection, do you follow the auto rules or the walking rules or the bicycle rules? And how do you give notice to the drivers which ones you're following? Anyway, that's the thing that you've got there. So you've got the successor trustee, which takes on the obligation when you die or become incompetent. And that's something that a trust can do that a will can't do. If you become incompetent before you die, you can avoid a guardianship and conservatorship by having a revocable living trust. Now, I know you think it's not likely that I'll be incompetent, which is true, but it doesn't cost anything to put that into the trust to avoid a guardianship conservatorship, which instead of having one lawyer like a probate takes, it's going to take two lawyers or maybe three lawyers, and lawyers' fees mount up, so that's the reason to save on that. The beneficiary is you during your lifetime, and then it's your heirs afterwards. So a living trust, I've got a diagram up there that shows the trust in the middle, your house, your stocks and bonds, your money, your investments, all go into the trust. And then you get the advantages of a living trust. You avoid court interference. The judge is not going to be sitting there with his little visor looking over all your papers and telling you that you've got to do it this way because that's the way the Maricopa County Superior Court does it. It's less expensive for your heirs because you're not paying me or some other lawyer to go down there. It eliminates the 4-month notice to creditors, which is what starts the lengthy delays, and it's private. The vultures are no longer looking at your trust because it's not available to them. It's between you and your heirs. The disadvantage of the trust, it costs more than a will. We already established that there are no $35 wills, but trusts are a lot more expensive than wills. It's a nuisance. And the one that I see the most frequently is somebody went to a lawyer, got a nice trust made, put the house in the trust, and 15 years went by and they never transferred anything to the trust, and they decide they don't even have a trust, and they come see the lawyer to make a new trust, and he looks up their real estate and sees it's in a trust and says, "Where's that trust you made in 1980? "Oh, we didn't know that was any good anymore." Well, you get a tax bill from the county assessor every single year that has the name of your trust on it, and you should be taking care of it. So that's a nuisance. It's a nuisance just to, in Phoenix, it's not a problem dealing with your bankers and investment people. They all know what trusts are. But you get on the East Coast dealing with, and I have a sort of a rule, the further east you go, the harder investment houses are to get along with. Charlie's saying, yeah, he knows about that. He's from Philadelphia. Anyway, it's a nuisance to deal with that. Possible mismanagement. You cannot mismanage your trust. You can take all of the assets in your trust and go to Las Vegas and invest them and lose them, and nobody can say a word. That's your right, whether you have a trust or not, to spend your money the way you want to. But if your successor trustee takes even a little bit and goes to Vegas and invests it, he's breached his fiduciary duty to the beneficiaries, and they have a lot of clout. So that's the mismanagement that we're looking for. Taxes, we already talked about taxes, but this chart's different. This is how much estate taxes you could look for going back when the exemption applied back to 06. You were good up to $3.5 million. Now it's 12 million, and it's a little more than 60,000 because it's now indexed to inflation. But this is going to drop back to 6.5 million in 26. So, yes.
We should die soon.
You should die. Well, that's something you want to think about going into 26. If you're taxable, do you really want to have a living will? Or how do you want the living will written? We don't have assisted suicide in the United States, but I was listening to public radio this week, and they had an article about a guy that went to Switzerland to have himself put down. And Oregon does, okay. That's something we won't get into. I just want you to know it's available. Okay, we don't need that slide.
So say,
Yes.
just to say, we're living now in 2023. You're anticipating 2026. What you're really saying is your estate planning, instead of just being a solid document, it should be a process of going with your estate at least over the next 3 years, anticipating that those estate tax laws are going to change.
Yes, absolutely true.
So the fact that you're doing something now, you're really doing something in anticipation of something 3 years and beyond.
Right, and that brings up a point that it may go lower than that. So you need to keep yourself up to date. It's not infrequently that I talk to somebody just casually and talk about their trust or whatever, and they say, I don't need to do anything. I did it 15 years ago. Well, I'm here to tell you, in 15 years, it's out of date. No matter what size estate you got or what your plan was, it's a problem. So you need to, our rule at the office is we want to see our clients every 5 years, but I can tell you for sure in 2026, we're going to see all of our clients because with the rapid inflation we've got, a lot of people that were not 6 million are going to be 6 million. I won't, okay. Income tax, there's more to income tax than estate tax. The top one is capital gains tax. And to all of you, the capital gains tax is a lot more important than the estate tax because it applies to everybody. And what the capital gains tax does is say, when the current capital gains tax says, when you die, your heirs get a step up in basis. That means if you paid $100,000 for your house and it's worth $1 million now, it suddenly became worth $1 million and you don't have to pay capital gains tax of 20% on that $900,000. So that's the first tax that you're going to have. And if they eliminate the capital gains tax, which there's talk about that, that's going to be a disaster for all of America because everybody has capital gains in their house and usually in their investments. Then we'll talk about IRAs, gifts to charity, to avoid taxes on IRA. If you've got a healthy IRA and you want to give the best gift you can to charity in December every year, that's when you make your gift or your mandatory distribution. So that's a really good tax, a really good thing to do to avoid taxes. And then the last one I've got up there is the Arizona tax credit. You can give any charity that serves the poor, which guess what? That's what charities do, $400 and get a credit. What does that mean? That means you owed the state $400 in income tax and you're getting credit for that $400 that you gave to the charity. You don't get out of paying the tax, but the charity gets the money. So that's a really cool idea. Anybody got any questions about that? Charlie? You're okay. Okay. I can't hear.
We don't have that $400 Arizona tax.
That's a good reason to become an Arizona resident. Then we can tax your estate a little bit. No, there's no Arizona estate tax. I'm kidding, Charlie. That's one of the advantages of living in Arizona. We have a low income tax and no estate tax. So the only estate tax we talk about is the federal one. Now, I've got a chart up here that shows 15 circles. We're not going to cover all of them, but a comprehensive estate plan is more than a will and more than a trust. And I can't tell you how often somebody comes in with an older trust in a nice big binder and says, this is my trust. Well, part of it is maybe 40 pages, maybe if it's one of our big trusts, 120 pages, but the rest of it is powers of attorney and health care things that you need, but it's not your trust. And when the bank says, we want a complete copy of your trust, they don't want that whole book. They only want the trust part. And if your trust is very complicated, we'll make up a document that you can give to them that tells the parts that they need to know. Okay. Healthcare provider. Healthcare power of attorney designates who's going to be in charge of your health. And with the health laws that we've got, if you're in the hospital and somebody shows up to visit with you other than chit-chat, the hospital's going to say, wait a minute, this person doesn't have any authority to deal with us. And that comes up when you're starting to lose competency. And guess who gets to decide your competency? It's the hospital. So you're going to want to be sure that you've got a stable person as your health care power of attorney that understands what your wants and desires are. Now, this one says plain power of attorney, but it's a general financial power of attorney that covers everything that's outside your trust. So everybody should have one of those. I've argued with several clients about that. Well, I don't need that because everything's in my trust. Well, I'm here to assure you that the friendly helpers that you've got at the insurance company and the bank and other places, over time, will take some of your property out of the trust. It happens with regularity. The first time I encountered that as a young lawyer, I had done a trust for a lady, and part of her investment plan was $200,000 in CDs at the bank. And on the day that we signed it, she was sick, so I took her to the bank, and she put it in there. And within 4 years, she died. And the day after she died, her daughter called me, not to tell me she died, but to read me out because I didn't put those certificates of deposit in the trust. And I said, Judy, I did that. I took your mom down there, and it was done. Your friendly bank, when they renewed them in mom's name, and mom didn't catch it. So all of those are subject to probate. Remember, they're over $75,000. So that's why you need a current good power of attorney that covers all likelihoods of anything outside the trust. Remember, though, that the power of attorney dies when you die. So if that stuff is still outside the trust when you die, it will go to probate, just like the CDs I was talking about. Nomination of a conservator. The last thing you want as a person is a court-appointed conservator, because then you have to file reports with the court annually. We've got one going on right now. It's been going on for quite a while. The fees on that are $1,800 a year to file a simple one-page accounting. That's outrageous, but if you had a trust, there wouldn't be any charges at all, and you'd be happy camper. A letter of instruction that covers various personal matters. These are things that are outside the trust that usually amount to 4 or 5 things that have to do with how you want your funeral handled, who you want to notify. You don't have to notify everybody in the world. 5 or 6 people that are going to outlive you need to be on your list, because your kids will call them and say, Mom died yesterday and the funeral's going to be, or the funeral's pending, or whatever it is. So the various personal matters that are outside the trust, one of the things we used to do and we're not doing anymore, but in Arizona we have a unique rule. If you want to be cremated, unless you have a signed and notarized document, it cannot be done without all of the heirs signing off. That can be a real problem, although I'll tell you a story about one that I had. A gal died. She had 3 daughters. And one of them called me and said, hey, Mom died, and the funeral home's saying we can't cremate her unless I and my sisters all sign off. And I said, that's correct. She said, well, my sister won't sign off. And I said, okay, give me your sister's phone number. I'll give her a call. So I called her sister, and her sister gave me all this stuff about why she wouldn't sign off. And I said, you realize that if you don't sign off, the funeral's going to cost $10,000, and you're paying for 1/3 of it. She said, oh, Mom wanted to be cremated. So, yes.
The letter of instruction should be notarized?
Well, that particular part needs to be notarized. The rest of it doesn't. Your tangible personal property can just be signed. But if you're going to do the instructions on cremation, they've got to be notarized. Yeah. And that, okay. A pour-over will. This is one I argue with clients about a lot, too. I don't need a pour-over will. Everything's in my trust. Well, we just went through all the horror stories about how your friendly providers take stuff out of your trust. So that's why you need one. And that's why we needed one with the lady with the $200,000 in certificates of deposit. So you need a pour-over will. The whole thing is sort of a takeoff from what Charlie was saying. You want a bulletproof system, but to keep it bulletproof, you've got to update it every so often. And that means updating the documents and checking the property and making sure it's still in the trust, because it can get out really easy. And then if you're married, you should have a property agreement between spouses. I like to write those for long-time married couples to say that it's community property. The reason is you get a full step up in cost basis on the first death. The rule on separate property is the one that died gets the step up in basis. There's only 8 states that are community property states, so we've got a substantial tax advantage to doing a will or a trust in a community property state. Because especially, remember earlier I said that you've probably defeated your community property, but our statute says a simple writing signed by both of you will convert it back to community property. And we can even convert it back to community property only for estate planning purposes if you're worried about getting a divorce. So there's ways to lower your tax bill there. Now, this guy went out goat hunting up in Idaho. It was in the fall of the year, a little bit later than this, but a big storm came in and it snowed 50 inches where he was, and he didn't come home. And by Christmas, they decided he died. Well, then in January, he comes walking in and says, I've been snowed in and couldn't get out of there. And he got a second chance to rethink his estate plan. You're not going to get one, and I'm not going to get one. We need to do it right the first time and keep it up to date. So you can read that in. Okay, don't procrastinate. You won't get a second chance. Speak with me. Okay, I don't know how we're going to get you to sign these things for a free appointment, but if you signed in, I'll call you. And if you didn't sign in, I won't call you. But you get a free appointment for coming and listening to me today, and you get all the questions you want today. Thanks for being here. Yes?
After you die, who besides the successor trustees?
You decide that when you make the trust.
Right, but besides the successor trustee, is there anybody else who has a right to see your documents?
Yeah, the beneficiaries do to the extent of their interest.
The whole document or just part?
To the extent of their interest. My practice in most cases, unless I've got clear instructions from the client, is to give the whole document to all of the heirs. But if you've got a really badly divided family, you may not want to do that. Yeah. Charlie, you had a question?
And you might want to say something about how you want to be remembered, specifically through your church. And I'm thinking of the memorial garden.
What I'm thinking about doing that's a good idea, Charlie. Nobody that I know of spends a bunch of time working on the obituary, but that's something you ought to put some thought into, especially where you want people that aren't beneficiaries of you to give to your favorite charities. But most of you probably know McCloskey. What's his first name? Weatherman on Channel 10. Corey. In one of his earlier jobs, he was an obituary writer. So I asked him if he would do a seminar on obituaries, and I was thinking about aiming it at lawyers, but I think it probably will go over fairly good with. And if you've watched him on the weather very often, you know he's kind of funny. So anything he does on obituaries would be lighthearted. But he spent a couple years writing obituaries when he was a young journalist. So, yes.
I recently received something, and I think I'm correct on this, that one of the banks that
No. The usual objection is we won't put multiple trustees on. But the solution is there's another bank across the street.
So as far as doing that with the bank, do you have to take the whole will or the trust in, the trust into the bank, or how do you get it put into the trust?
I didn't hear the question.
Regarding a bank, to
Yeah.
get the attorney that does your trust is not going to do the bank part for you.
Correct.
Do you just take the trust in and show it to them and say, I want it in the trust?
Yes. And if they're like most of the banks, their headquarters are in Ohio or at the end of the world somewhere, and they're going to send it to their lawyer there, it's going to cogitate over it a while, hopefully send them a bill, and eventually tell them this is the way it has to be set up. And most of the time that can be done in an hour, but sometimes it takes more time than that. But
Start at the local bank. Start the process at the local bank.
yes, go to the bank. And if your trust is very complex, you should have a certificate of trust that takes out the complexity and makes it easy for the bank. Sharon?
I have a similar question. Does that mean, like, every account you might have in a bank, they all have to be, none of them can be in just your name? They have to be.
That's right. With one exception, and it doesn't apply to you, but if you've got a spouse, your spouse should always be the beneficiary on your 401k because there's a tax advantage to that. If you don't have a spouse, your trust should be the beneficiary on your 401k and on your life insurance because the trusts are set up in such a way that if the beneficiaries are incompetent, the successor trustee can be the trustee to take care of their money without having this expensive proceeding in court. Do you have another question, Charlie?
Question for you. What are your views about having knowledge of user names, passwords, special access to accounts that today you've got to go online digitally, know your username, password, and for every account, it's got to be different.
At the very minimum,
State planning standpoint, I would like to hear your thoughts on how
well,
you provide.
at the very minimum, you should have a place where those are kept that your successor trustee knows about but doesn't have access to. We're kind of conscious about that. When you sign that financial power of attorney, that's a bearer document, and that means whoever's got it can cash all your checks. So that one, along with all these passwords and codes that you've got nowadays, need to be kept someplace that's 2 steps away. They're going to have to look at the trust to find out where it is. Then they're going to have to get it, and you're going to have to be trustworthy enough that you believe that they'll take care of things the way you set it up. If I've had clients say, well, I don't trust anybody as far as I can throw a refrigerator. I said, well, you're not a good candidate for a trust or anything else because you've got to have some trust in this world. Did that answer it?
I was just interested in your point of view because today, if you go online to your account, many times they're sending you yet another message to your cell phone
Right.
asking you for a 6-digit number. So you can't even throw your cell phone away if you're going to have access to that person's account.
You're correct on that. Yeah.
What about burial?
You know, interesting thing, I used to be involved in a whole lot of prepaid burial plans, and initially I thought they were horrid, but I've decided that they're pretty good except for one problem. Most prepaid burial plans include digging the hole, but not covering it up. And guess what? That's a substantial fee. I thought about getting a backhoe and quitting practicing law. But anyway, that.
Well, the reason why I ask is recently we've had to investigate, a burial plot
very expensive here in Scottsdale.
I'm sure that that's the case, but you don't have to be buried in Scottsdale, or you can be cremated and put back here for $2,000.
It's the best deal.
That's the best deal in the county.
I'm just saying, it's, yeah, and in fact, the discussion was, well, if we wanted to go there, we would actually have to pay like a premium for someone that already has a plot, and you would,
In other words, the cemetery is sold out, so it's a secondary market.
the secondary market has gone quite well.
Notwithstanding that, in most cases, cemetery lots are a drug on the market. They're not really sellable as long as the cemetery has lots to sell, because they can always undercut what you're going to do as a reseller. So somebody that goes and buys cemetery lots for their spouse, their kids, their grandkids, they're going to wind up with a lot of, in my view, it's not a good investment. You do better buying a rental house or something. And you don't have to deal with the bureaucracy at the cemetery. That's an interesting sidelight too. Cemeteries don't have a lot of statutes that cover what they do, so you're sort of at their mercy. Anybody else? Hey, I've enjoyed it, guys. Thanks for coming. If you didn't sign in at the back, and I'll send you an invitation, or I'll call you up and say, come and see me for free. This is the only time you get to talk to a lawyer for free, by the way. And I made it all the way through without telling a single bicycle story. But I'll tell you one right now. In July, I rode my bicycle across Iowa for the 37th time. And I loved doing it. It was hot and humid and hilly and difficult, but it was 500 miles in 7 days. But if you want to stay healthy, ride your bicycle. That's Sam's medical advice.
As long as you don't get run over by another bicycle or.
There was a recent.
I saw that on TV where the police officer was run over by the juvenile delinquents on purpose.
Yeah.
And they videotaped themselves doing it. I mean, there's 2 kids that are going away for murder. I just saw the little piece just before they ran into him. I haven't seen any of it. I understand on Wednesday last week it was on TV all day long. But that's one of the risks. Sam's rule on that is pick your places and pick your times. Yes? Private fiduciaries are one step down from banks. When you have a bank as the fiduciary, you've got the full bank to go against if they screw up. Private fiduciaries usually have very limited assets, so if they screw up, your heirs are out of luck, which is basically the same as what would happen if you had a friend do it that took all the money and invested it in Vegas. But private fiduciaries, I've used them, and all the ones that I'm familiar with, I'm not found out that they're stealing their clients' money, but you do see those articles in the paper every once in a while. So usually the advantage of a private fiduciary over a bank is a bank will not be your health care agent, but a private fiduciary almost always will. And if you don't have any heirs, they probably come see you once a week when you're in the nursing home. Anyway, anybody else got anything else you want to talk about? Yes?
One suggestion, Sam, is having family
conversations about your estate plan? Because you've made this sound like it's a very individualistic type of process, whereas in fact, if it's really successful, you're engaging more than just one other person to be part of this estate plan.
Yeah, you're correct on that, Charlie. And that's the hardest part, but there are families that have a Thanksgiving dinner and that's all they talk about. Then they make up rules, whether they have spouses and whether they have grandchildren or whoever's involved. And probably the most successful ones, the patriarch decides who's going to be in the family meeting. And if I was advising them, I'd say you've got to have everybody there, even the dissenters, because you want them to feel included, and that's going to make things easier.
I mean, to me, the homework assignment for today, for everybody here,
Regardless of what your estate plan is to go and have a conversation with another family member and tell them you've had a great learning experience hearing about estate planning. And
Right.
just starting that conversation is not easy amongst family members.
Right. 9 times out of 10, I'm dealing with the next generation when they're doing their estate planning. And I usually ask a question that goes toward how are your parents doing, partly because I want to know if they're going to inherit a large amount, but partly because I want to know if their parents are doing estate planning. And if they're not, I tell them just straight out, you need to go sit down with mom and dad and explain to them that you did an estate plan and you're only 37, but they're 67, and they need to think about getting some powers of attorney in place. I actually had a couple bring in mom and dad on a deal like that. When I got down to the living will, the father says, son, I'm not dying. And he's there in front of me dragging his oxygen bottle. And I said, okay, have it your way. We won't do any living will. But we did the powers of attorney, and it was a good thing we did them. But anyway, none of us have figured out how to get out of this world alive, including Jesus Christ. So I think we're destined to die. It's just a matter of when and how well prepared we are. Okay. I'll come down off the podium and talk to you if you want. But you're free to go. You've got my permission.